I'm Judge Carolyn Tornetta Carluccio, Chair of the Montgomery Bar Association Community Outreach Committee. Our courts are widely regarded as some of the best in the world, but not all of our laws make common sense. That's why we have lawyers and judges. As Americans, we all have rights, and lawyers are here to protect those rights. In this segment, Marc Jonas and Kellie McGowan of the law firm of Eastburn Gray will help you understand what you need to know about the Sunshine Act.
Hi, have you ever attended a meeting of your local township, borough, city, county? Have you thought about attending meetings of a school district or a state agency? If so, you really want to know about a Pennsylvania law known as the Sunshine Act, also known as the Open Meetings Law, passed in 1986. This has a very specific policy, and that is to ensure that citizens like you have notice of and the right to attend all meetings at which what is called and defined as agency business is discussed or acted upon.
And all public agencies are subject to the Sunshine Act, and these agencies include the Pennsylvania General Assembly and the municipal governing bodies of boroughs, cities, and townships. Also subject to the local agency law are appointed committees authorized to take official action or render advice on official action, such as planning commissions. Today we are going to focus on local agencies.
So this may mean a local planning commission or any body within.
The Sunshine Act requires that all public meetings be open to the public, subject to notice requirements, and provide for public participation. A meeting is any prearranged gathering of a quorum of the governing body or the agency body for the purpose of conducting or discussing official business. A quorum is a majority of those elected to the body or appointed to the body. There's no location requirement. A meeting can be held either at the governing body's place of business or any other location, so long as it's subject to public notice.
The requirement of the Act is that there be public participation. The agency must provide sometime during the meeting a reasonable opportunity of the public for you to comment. This requirement does not give you the right to speak carte blanche or at any time. Generally, a local agency will provide a specific time on the agenda for public comment. It might be at the beginning, it might be at the end, or it might be during any discussion item.
One of the fundamental requirements of the Sunshine Act is that all official action, which includes discussions, deliberations, and votes on agency business, must take place at a meeting that is open to the public. There are few exceptions to this rule. One exception is an executive session, but executive sessions are limited in what an agency may discuss within that session. One reason is litigation, but litigation is limited to existing litigation or litigation which is contemplated. The second reason is personnel matters, but personnel matters must be discussed with respect to a specific individual. And again, no official action may be taken in an executive session. They may discuss and deliberate, but all official action must be taken at a meeting open to the public.
The statute also has requirements for the keeping of minutes by the public agency, and those minutes have to have certain substantive requirements. There is also a requirement that there be a schedule of the meetings in advance.
On behalf of the Montgomery Bar Association's Community Outreach Committee, a group of lawyers and community leaders from Montgomery County, I'd like to thank today's presenters. Be sure to check back soon for more information on what you need to know about the laws that impact each one of us.